one remark about a panelist, which gives me a chance to talk about a study that our school at ASU is involved with. So Steph will be introducing all the panelists. One of them, Roger Smith, is part of the steering committee, sort of executive national committee of a study funded by the U.S. Department of Education and the National Endowment for the Humanities. It's been operating since October of last year, supposed to run through October of this year. It's a national study about U.S. history and civic education in K-12 public schooling. And our school at ASU, the School of Civic and Economic Thought Leadership, was invited by a team that began in Massachusetts, an institute at Harvard, an institute at Tufts. Peter Levine is here representing that institute at Tufts, and iCivics in Massachusetts. And they reached way out to us in Arizona and also intellectually on the conservative side to join this national coalition to put in for the study, and we did receive the grant from the Department of Education and NEH. So we're grateful that very distinguished scholars like Rogers have agreed to serve on that study with us. So to our next panel on American citizenship and the Constitution, what the 14th Amendment teaches us. I'm delighted to introduce the panel moderator and chair. Dr. Stefanie Lindquist is the Senior Vice President of Global Academic Initiatives at Arizona State University. Prior to that, she served as Deputy Provost and Vice President for Academic Affairs at ASU and Foundation Professor of Law and Political Science at ASU. She also has served as Dean of the University of Georgia's School of Public and International Affairs and a Dean at the University of Texas School of Law. Steph's scholarship focuses on the U.S. Supreme Court, constitutional law, and administrative law, including her book, Measuring Judicial Activism. And Steph has been a friend of this new school since our launch in 2017, and she continues to serve on the steering committee that plans our major speaker series, the Civic Discourse Project, including our annual two-day conference. Please join me in welcoming Steph Lindquist and this panel.
Good afternoon, everybody. Welcome to those of you who are coming from outside of Arizona. Welcome to Arizona State University. And to those colleagues that are here from Arizona State, thank you so much for coming to this conference. As Paul noted, I've been very engaged with the School of Civic and Economic Thought and Leadership since its inception, since we hired Paul and Carol to head this school and to drive it forward. And I couldn't be more proud of the kind of programming that we've been able to develop in connection with this new school. We've had a series, so this is the third and sort of in a three-year series. The first focused on free speech on campuses. The second, and that included a conference and a speaker series of very distinguished people. The second was on party polarization and how that was affecting American politics. Again, a conference and a speaker series, and now this year on citizenship. So we are very pleased to have you join this intellectual dialogue with us and to welcome you to our beautiful campus. I hope you get to enjoy, for those of you who are visiting, I hope you get to enjoy Phoenix and the gorgeous weather that we have. There's great hiking around here. Sedona's only an hour and a half away. So I do recommend and certainly encourage you to enjoy our environment here, our desert environment. And I just also want to note it's sort of a banner day for the Memorial Union when it comes to law and politics. Just around the corner, as I was walking in, I noted that the Law and Society Review has recently come to ASU through our hiring of Rebecca Sandifer, who is a MacArthur winner, and she came to us from Illinois and brought the Law and Society Review with her. So I'm very pleased to make that announcement, and if you walk around the corner here on this hall, you'll see that there is a little reception ongoing for the Law and Society Review. But don't leave this panel. I was not encouraging you to do. I just wanted to make that announcement. I'm also very pleased to have the opportunity to introduce our panelists today on a panel that we've entitled American Citizenship and the Constitution, What the 14th Amendment Teaches Us. And we have three very distinguished panelists who are going to speak for about 20 minutes each, and then we're going to have the opportunity for the audience to ask questions for this very, very timely subject that is the subject of this conference. So to my left, I'm pleased to welcome Elizabeth Beaumont. She's an associate professor of Politics and Director of Legal Studies at the University of California at Santa Cruz. And her recent book, The Civic Constitution, Civic Visions and Struggles in the Path Toward Constitutional Democracy, was published by Oxford University Press in 2014. Obviously, a book of central importance to what we're talking about today, and I'm sure she's been working on many things since 2014 she'll tell us about in her comments. To her left is Roger Smith. He is the Christopher Brown Distinguished Professor of Political Science at University of Richmond, and his research centers on constitution. Did I say that right?
I'm at Penn. He's at Richmond. I'm Roger Smith.
What did I just say?
Kurt Lash.
Sorry, got them confused. I'm getting old. What can I say?
They can see. They can read.
I do make mistakes every once in a while. Apologies. Rogers at University of Pennsylvania. I knew that. What's distinct? He's an incredible scholar. Rogers is. I've known of his work since I was a graduate student in the 1980s. He was elected as a fellow at the American Academy of Arts and Sciences in 2004, and in 2018 and 2019, he was the president of the American Political Science Association. So we're very pleased to have him. He is at the very end of the panel. Apologies, Rogers. And in between Rogers and Elizabeth is Kurt Lash, who is the E. Claiborne Robbins Distinguished Chair in Law at the University of Richmond. And his most recent book, obviously of central importance to this conference, is entitled The 14th Amendment and the Privileges and Immunities of American Citizenship from Cambridge University Press in 2014. Actually, he may have written books since then, but that seems to me a title I wanted you to be aware of in 2014. So I'll turn it over to our panelists right now. Again, we have a student in the audience who is keeping time, I believe. Tyler, is that right? And so thank you to Tyler. And then after we've heard from the three panelists, and we can go, we actually decided upon a certain order. We're going to start with Kurt. Do I have this right, Kurt?
That's right.
And then Rogers, and then Elizabeth. So thank you very much, everybody.
All right, thank you, Stefanie, and welcome everyone to this afternoon's panels. It's a pleasure to be here, a pleasure to be in the warmer weather of Arizona, out of Virginia, and it's my role this afternoon to be the historian, to take put on the historian's hat, and put in perspective the citizenship clauses of the 14th Amendment. And I'll do my very best to stay within that 20-minute time period. The so-called birthright citizenship clause is the clause that actually opens Section 1 of the 14th Amendment. It declares all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This sentence is the first of 4 sentences that make up Section 1 of the 14th Amendment, a 5-sectioned amendment. This particular sentence was added only at the last minute, after the rest of Section 1 had been drafted by Ohio Representative John Bingham, finalized by the Joint Committee on Reconstruction, and passed by the House of Representatives. Although Bingham's original version of Section 1 did not contain a birthright citizenship clause, that was not a signal that they found the issue unimportant. The original omission most likely reflects Bingham's and the Joint Committee's belief that a birthright citizenship clause was unnecessary. For years prior to the Civil War, Republicans had claimed that the law already established that all persons born within the jurisdiction of the United States were citizens of the United States. In 1857, for example, almost a decade before he drafted most of Section 1, John Bingham declared in a speech, "Who are the citizens of the United States? All free persons born and domiciled within the jurisdiction of the United States are citizens of the United States since birth. Aliens become citizens only by acts of naturalization," end quote. In other words, the reason why Bingham did not add this principle to his first draft of the 14th Amendment was likely because both he and his fellow Republicans believed that birthright citizenship was already the proper understanding of current law. Now today, the birthright citizenship clause is most often described as overturning Dred Scott, Chief Justice Taney's opinion that blacks, including those blacks born in the United States, could not be considered citizens of the United States and therefore could not invoke the jurisdiction of the federal courts. And in fact, this opening sentence of the 14th Amendment formally overrules Chief Justice Taney's opinion. But in 1866, when the 39th Congress passed the 14th Amendment, few Republicans felt constrained by any statement of law announced by Taney in Dred Scott. In 1862, for example, in open defiance of Taney's opinion, Congress banned slavery in the territories. And after the Civil War, there wasn't a single Republican member of the 39th Congress that believed Dred Scott was worth the paper it was printed on. So again, it's no surprise that Bingham's original draft of Section 1 ignored Dred Scott and Taney's argument about Black Americans. The House of Representatives thought that Bingham's three-sentence draft was just fine, and they quickly passed this and made it the original version of Section 1. It was only later, in the Senate, that Michigan Senator Jacob Howard proposed adding the birthright citizenship clause to Section 1. Howard conceded that his proposed addition simply restated existing law. Nevertheless, he thought it worthy of addition, if only for greater caution. In fact, Senator Howard did not think that his proposal needed much discussion, since, quote, "The question of citizenship has been so fully discussed in this body as to not need any further elucidation," end quote. And that last statement by Howard is significant. The Senate had discussed citizenship early that session, but it was not in relationship to the 14th Amendment. Howard was referring to the weeks of discussions and debate over the 1866 Civil Rights Act. Drafted by a Senate committee and passed a few months earlier over the veto of President Johnson, the 1866 Civil Rights Act contained its own citizenship clause, which declared that, quote, "All persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States," end quote. There was some question at the time whether Congress had constitutional authority to define and regulate national citizenship outside of the context of immigration and naturalization. So now, 2 months later, Senator Howard was taking advantage of the debates over the 14th Amendment to add a clause that clearly established congressional power to define and enforce the rights of national citizenship. In terms of who was covered by the clause, Howard explained that the provision would not include the children of ambassadors or members of independent Native American tribes, groups not within the jurisdiction of the United States. Other than that, his proposed clause, quote, "will include every other class of persons, including the children of, quote, gypsies and Chinese immigrants," end quote. The Senate accepted Howard's proposition and his addition to Section 1. The House agreed to the change, and Congress quickly passed what is now a four-sentenced version of Section 1, and it reads as follows. "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Nor shall any state deny any person life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." With the addition of this new first opening sentence to Section 1, the entire section now had a kind of symmetry, a symmetry that you can see if you turn to your pocket constitutions, which I believe are provided for everyone as a part of this conference. I encourage you to do so. The first two sentences of Section 1 involve the rights of citizens. The last two sentences of Section 1 involve the rights of all persons. These two categories of rights, those of citizens and those of all persons, reflect a common antebellum Republican distinction between the positive rights of citizenship and the natural rights of all persons. The last two sentences, which we call the due process and equal protection clauses, again, protect the natural rights of all persons. Antebellum abolitionist Republicans embraced the Declaration of Independence and the idea that all men are created equal and endowed by their Creator with inalienable rights of life, liberty, and the pursuit of happiness. These were natural rights that no government could properly deny to any person. To abolitionist Republicans, these natural rights became part of the Constitution through the adoption of the Fifth Amendment and its declaration that no person should be deprived of life, liberty, or property without due process of law. Constitutional abolitionists like Joel Tiffany, Frederick Douglass, and Charles Sumner all insisted that the Due Process Clause alone established the pro-freedom nature of the American Constitution and rendered slavery unconstitutional in any territory controlled by the United States. After all, even if slaves were not considered citizens, they were persons, persons with equal natural rights and rights that were expressly recognized in the Fifth Amendment Due Process Clause of the federal Constitution. That Due Process Clause, of course, had been interpreted to bind only the federal government and not the states. This meant that even after the adoption of the 13th Amendment and the abolition of slavery, Southern states remained free to pass the Black Codes and deny freedmen their natural rights to the equal protection of life, liberty, and property. This problem was remedied by the final two sentences of Section 1 of the 14th Amendment, which declare, "No state shall deprive any person, citizenship or not, of life, liberty, or property without due process, nor deny to any person within its jurisdiction the equal protection of the laws." These are the sentences that invalidated the Black Codes and gave Congress power to enforce the equal due process rights of all persons in the Southern states. Now, what about those first two clauses? The first two sentences of Section 1 address an entirely different category of rights, those belonging to citizens of the United States. Unlike natural rights, the rights of citizenship are not held by all persons, but are held only by those who hold the unique status of being an American citizen. The Citizens' Privileges or Immunities Clause was drafted by, again, Ohio Representative John Bingham, and Bingham himself left no doubt as to what he believed were the rights of national citizenship. All of the personal rights enumerated in the federal Constitution were privileges or immunities of citizens of the United States, especially those listed in the first 8 amendments to the Constitution, known as the Bill of Rights. Although that original bill bound only the federal government, between the founding and the Civil War, Republicans in the North increasingly viewed that Bill of Rights as declaring the rights of national citizenship, rights that should be respected by both state and federal governments. Northern abolitionists repeatedly claimed that Southern slave states were violating the rights of American citizens to free speech, free press, and the free exercise of religion. In other words, to antebellum Republicans, slavery violated both the natural rights of persons and the constitutional rights of American citizenship, announced in America's Citizens' Bill of Rights. The problem was that neither Congress nor the courts had the constitutional authority to enforce the Bill of Rights against the states. Cases like Barron against Baltimore determined that the bill legally bound only the federal government, and Congress likewise lacked any enumerated authority to enforce those rights against state officials. So, in the opening weeks of the 39th Congress in 1866, John Bingham announced his intention to solve this problem by adding an amendment to the Constitution that would empower Congress to enforce the Citizens' Bill of Rights against the states. According to Bingham, quote, "It has been the wont of the Republic that there was not an express grant of power in the Constitution to enable the whole people of every state by congressional enactment to enforce obedience to these requirements of the Constitution," end quote. When he produced the first draft of what became Section 1, Bingham further explained, quote, "The proposition pending before the House is simply a proposition to arm the Congress of the United States, with the consent of the people of the United States, with the power to enforce the Bill of Rights as it stands in the Constitution today. It hath that extent, no more." When Senator Jacob Howard presented Bingham's final version of the Citizens' Privileges or Immunities Clause, Howard explained that the privileges or immunities of citizens of the United States involved the rights of citizens enumerated in the Constitution, including those covered by Article 4 and also the personal rights protected by the first 8 amendments. Finally, a few years after ratification, Bingham gave a speech which left no doubt as to his understanding of the rights of national citizenship that were now protected by the opening sentences of Section 1 of the 14th Amendment. The privileges and immunities of citizens of the United States, Bingham explained, are chiefly defined in the first 8 amendments to the Constitution of the United States. He then quoted, verbatim, Amendments 1 through 8. And he then announced to his colleagues, "These 8 articles I have shown never were limitations upon the power of the states until made so by the 14th Amendment," end quote. In conclusion, in some ways, the citizenship clauses of the 14th Amendment seem simple and obvious. The first sentence announces what was already broadly held to be the correct understanding of the law regarding birthright citizenship. The second sentence seems to do nothing more than require the states to respect rights that were already enshrined in the text of the Constitution. But in fact, these provisions were profoundly transformative. Previously, the states had broadly controlled citizenship, to the point that establishing national citizenship often turned upon first establishing state citizenship. The new Citizenship Clause turned that formula upside down and announced that national citizenship came first, and it was defined and protected by the nation's Constitution. The Citizens' Privileges or Immunities Clause was even more profoundly transformative. The people no longer looked at the Bill of Rights as a federalist declaration of limited national power, one protective of the reserved powers of the states. The words in the Bill of Rights now represented the rights of the American people, rights that the federal government now had power to enforce against state abridgment. Together, these two clauses established that national citizenship was finally more than a theory. It was now enshrined in the text of the Citizens' Constitution. Federalism had not been erased, but henceforth it had to compete with a newly robust conception of national citizenship and national freedom. Thank you.
Good afternoon. I'm honored to be here at SCETL and part of the discussions of major issues of citizenship today. Two recent arguments by leading conservative thinkers can help frame my discussion of citizenship and the 14th Amendment. Charles Kessler of the Claremont Institute has a forthcoming book called Crisis of the Two Constitutions that elaborates an argument he and others have been making for some time. He sees America as polarized between two rival constitutional visions. The first is a conservative one focused on the original Constitution, committed to limited government, and grounded on the natural and divine rights of the Declaration of Independence, which should guide immigration, citizenship, and educational policies, and all else. The second is a liberal or progressive vision of the Constitution as a living document that should be interpreted to aid in transforming America into an ever more perfect union understood as a predominantly secular social democracy. Kessler sees these two constitutions as deeply at odds. We're fortunate to have in this conference Christopher Caldwell, whose recent book, The Age of Entitlement, similarly sees a rivalry between older conservative understandings of the Constitution and a liberal constitutional vision of, quote, an entirely new system of constantly churning political reform. He sees this rivalry as worsening in recent decades and fueling American polarization. But while Kessler traces living constitutionalism back to the progressive era, Caldwell stresses that it's the civil rights ideology of the 1960s, embodied chiefly in statutes of the 1960s as well as the 23rd, 24th, and 26th Amendments, that promotes immigration and citizenship policies expressing, quote, an all-embracing ideology of diversity. In recent years, I have similarly structured my teaching and writing on American constitutionalism as analyses of the profound clash between more traditionalist understandings and more progressive understandings of the Constitution. Much more than these authors, however, I stress two themes. First, that taken as a whole, contemporary American constitutional doctrines and institutions represent a deeply interwoven hybrid of earlier and more recent views. And second, this hybrid has emerged because core features of progressive constitutionalism, including commitments to popular self-governance, freedom of conscience, scientific progress, national innovations for the general welfare, and more inclusive and more egalitarian citizenship policies, all arise from developments fostered by core features of the original Constitution, even as they also challenge it in important ways. I stress these two themes because I think they're true, but also because they suggest that the very real tensions between these constitutional visions may not need to be as crippling as many fear. Today, I want to discuss how the 14th Amendment and its provisions for American citizenship fit into this broader frame of rival constitutions. My answer is right in the center. By this, I don't mean to invoke the numerological argument that the 14th Amendment is central because there are 13 amendments before it and 13 amendments after it, though that is true. I mean that the 14th Amendment is the hinge amendment. It can be seen in some respects as the culmination of what I regard as the best of the founding understandings of the American constitutional enterprise, the goal of having both our national and state republics work to secure the basic rights of citizens and persons more and more fully over time. This understanding and national powers to advance it are far more explicit in the 14th than in the original Constitution, though they still have important qualifications that I'll discuss. But precisely because it establishes this sense of constitutional powers and purposes more firmly, the 14th Amendment can be seen as the seedbed of subsequent efforts to make citizenship more democratic and inclusive in ways that necessarily involve embrace of greater civic diversity. Those efforts are central to the best versions of progressive constitutionalism that Kessler discusses, and to the civil rights ideology that Chris Caldwell analyzes. I think that seeing the 14th Amendment as the hinge amendment between what some call two rival visions of the Constitution and American citizenship supports a hope that may seem too optimistic. It raises the possibility that if we consider how we can advance what is best in the 14th Amendment, we might find ways to advance what is best in both conservative and progressive constitutionalism. How can we possibly do that? To cut to the punchline, I believe our fundamental task is to work chiefly through democratic processes, not court decisions or executive orders, to find and enact immigration and citizenship policies and other measures that materially benefit and display respect for as many people as we feasibly can at any given moment. By doing so, we may well find that we're able to expand over time the circle of we the people of the United States who enjoy secure possession of basic rights in keeping with the goals set for the nation first by the Declaration of Independence and then, as a response to grievous American failures, by the 14th Amendment. Such expansion of those included in We the People would also advance core goals of many modern progressive constitutionalists and civil rights advocates. That's the big picture of my discussion. I'll seek to support it by turning to the text of the 14th Amendment, whose origins Kurt has just illuminated. Section 1 begins with that citizenship clause, universally understood as definitively overturning Roger Taney's claim in Dred Scott that African Americans could not be citizens of the United States. It does so again by stating all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. The original Constitution did not define U.S. citizenship, in part because deep divisions already existed over slavery and citizenship for free blacks. The greatest single contribution of the 14th Amendment Citizenship Clause is to make it explicit that constitutionally, American citizens can be racially diverse, even though the amendment does not ban statutory racial restrictions on naturalization. But the Citizenship Clause also contains that qualifying phrase, and subject to the jurisdiction thereof, to which I'll return. First, let me remind you, as Kurt did, that Section 1 goes on to deny to the states power to abridge the privileges and immunities of U.S. citizens or to deprive persons of life, liberty, or property without due process of law, or to deny persons the equal protection of the laws. Section 5 of the 14th Amendment gives Congress the power to enforce these provisions and the rest of the amendment by appropriate legislation. It's significant that the 14th Amendment protects the rights of both U.S. citizens and persons who are not citizens. These provisions are plainly consistent with, and I think they're expressive of, the Declaration of Independence precepts that all are endowed by their creator with certain inalienable rights, and that governments are instituted to secure these rights. Republican governments do so, moreover, in part by creating forms of citizenship that protect rights. For even though the protection of rights is not solely for citizens, possessing full citizenship can help to secure them. For most of his life, Abraham Lincoln did not urge African American citizenship, preferring colonization schemes. But he eventually accepted not only that African Americans should be citizens, but that at least some must have voting rights to protect their interests. Urging that position cost Lincoln his life, but it came to be embodied in the 15th Amendment. Though the 14th Amendment did not go so far, it not only made the duties of states to protect basic rights more explicit, it also gave Congress more explicit responsibility and more power to make sure the states, as well as the national government, did their jobs. In all these regards, the 14th Amendment not only added fresh constitutional powers and commitments for Americans to pursue the Declaration of Independence project of securing basic rights, its example made it more possible to see American constitutionalism as a continuing reform project in which legislative powers, if need be national legislative powers, could and should be used to enact more racially inclusive and more substantively egalitarian and democratic forms of citizenship over time. Those conceptions are central to most forms of progressive living constitutionalism and modern civil rights ideologies. Although the proponents of progressive constitutionalism, precisely because they wanted to make American governance more democratic, have generally preferred to rely on legislation or direct democratic decision-making, not constitutional amendments, it's nonetheless true that after the 15th Amendment, the next 4 amendments, all products of the progressive era, express these progressive constitutionalist views. Through them, the Congress gained power to enact progressive income taxes, providing revenues for national reform projects. Voters gained the power to elect U.S. senators directly. Women gained voting rights. The social engineering-minded progressives also enacted prohibition, but later proponents of living constitutionalism recognized that experiment as a failure and ended it. Energized in part by the civil rights movement and what Chris Caldwell termed civil rights ideology, the amendments of the 1960s then gave D.C. voters representation in the Electoral College, banned poll taxes, and gave 18-year-olds the vote. These developments placed in the Constitution's text progressive commitments to greater democracy and greater protection for the citizenship rights of all, in ways partly inspired by the inclusive citizenship and equal protection guarantees of the 14th Amendment. Yet while these developments were partly inspired by the 14th, they also went beyond it. Kessler and Caldwell are not wrong to say that progressive constitutionalism and civil rights ideologies have less concern for limited government, states' rights, commitments to unchanging natural rights, and a variety of traditional values and practices than most, if not all, of the framers of the 14th Amendment did, even though those framers expanded national powers more than ever before. To grasp the relationship of the 14th Amendment to American citizenship fully, we must also acknowledge the traditionalist exclusions from full citizenship the amendment authorized. Section 2 apportions members of the House of Representatives to the states on the basis of the whole number of persons within their bounds, but it excludes Indians not taxed. They do not count for purposes of representation. And it reduces representation when states deny the vote to any of their male adult citizen inhabitants for any reason other than participation in rebellion or other crime. It thereby permits denials of the vote to female citizens. And Section 1, again, has that much disputed qualifying phrase which limits citizenship to those who are not only born or naturalized in the United States, but also subject to the jurisdiction thereof. Based on the congressional debates over the 14th Amendment, scholars almost unanimously agree that this language aimed to deny birthright citizenship to children born to diplomats, viewed as still residing in their home countries, to children born to invading, occupying armies, and more controversially, to Native Americans born into tribes. Most of the 14th Amendment framers saw these Native Americans as born partly under the jurisdiction of their tribes and so not fully subject to the jurisdiction of the U.S., even though the U.S. claimed the tribes were dependent nations over which the U.S. had ultimate authority. In the 1884 case of Elk versus Wilkins, the Supreme Court agreed that 14th Amendment birthright citizenship did not extend to Native Americans born into tribes, and in the early 20th century insular cases, the court held that persons born into the unincorporated territories the U.S. acquired via the Spanish-American War were also not 14th Amendment birthright citizens. In Wong Kim Ark versus U.S. in 1898, the Supreme Court did hold that children of immigrants to whom Congress had granted permanent residency were 14th Amendment birthright citizens. But the court never altered its interpretations of the 14th Amendment as permitting exclusions of women and Native Americans not taxed from voting, and as excluding persons born into Native tribes or in unincorporated territories from constitutional birthright citizenship. It's also never addressed the question of birthright citizenship for children born to immigrant parents present on U.S. soil in violation of congressional laws. Even so, women have gained the vote through the Progressive Era 19th Amendment. Congress also extended U.S. citizenship to all Native Americans, whether or not they desire it, via 1924 statute. Congressional civil rights laws in the 1960s and 70s then curbed many state-level policies and practices that disfranchised Native Americans. Congress has also extended via various statutes U.S. citizenship to all those born into its overseas territories, except American Samoans, many of whom prefer to be American nationals, not citizens. For 3 decades, Congress has also repeatedly refused to take up numerous bills that have sought to deny birthright citizenship to children of unauthorized aliens. So while as a matter of constitutional law, the exclusion from voting and birthright citizenship that the Supreme Court has discerned in the 14th Amendment still stand, Congress and later amendments have made American citizenship more inclusive in many respects. What are we to make of the 14th Amendment's exclusions? What is their significance for assessing the relationship of the 14th Amendment to American citizenship? What significance, if any, do they have for the rivalry between conservative constitutionalism and living constitutionalism that many now perceive? Let me advance 2 responses to these complex questions without claiming to be able to establish those answers definitively. First, I think the most generous interpretation of the exclusionary features of Section 1 and 2 of the 14th Amendment is that most of its framers and ratifiers thought, and rightly thought, that they were taking a big step forward as part of the Declaration of Independence project of securing basic rights for all. All but the most radical among them, however, still saw that project as necessarily a gradual process, as Lincoln did, so that enfranchising women and making citizens and voters of all Native Americans could and should wait for another day. Many have feared that the amendment would not pass if it appeared to do anything more than to extend citizenship without voting rights to black men. On this view, the 14th did not represent the full culmination of the Declaration of Independence project, though we can still see it as an historic advance. Second, I think that Section 5 of the 14th Amendment, like the parallel enforcement provisions in the 13th and 15th Amendments, should be read as signaling that henceforth Congress was to have enhanced authority and responsibility to make sure that American governments at all levels protect the basic rights of all persons and the privileges and immunities of U.S. citizenship. On this interpretation, it is an amendment not constitutionally wrong for expansions of birthright citizenship to Native Americans and territorial inhabitants to come through congressional statutes, or even for Congress to consider modifying birthright citizenship, though I think doing so would be a mistake. All this is so despite the undeniable fact that many of the arguments used by constitutional framers, Supreme Court justices, and congressional legislators to limit birthright citizenship have rested on denials of racial equality that are inconsistent with the best reading of the 14th Amendment and with moral truth. To be clear, I do think the courts have the responsibility to enforce the amendment through appropriate interpretations, and I've joined briefs arguing for 14th Amendment birthright citizenship for territorial inhabitants. I also think, however, Section 5 shows that the framers of the 14th thought Congress should be, probably had to be, the governing body with greatest ultimate responsibility for enforcing the amendment. And I believe that if we adopt these 2 responses to questions of the relationship of the 14th Amendment with its exclusions to American citizenship, we can see the amendment as not only the hinge between more conservative and more progressive visions of the Constitutions, it is also a 2-way bridge between them. My first response suggests that if, with many constitutional conservatives, we understand the Constitution as a project of securing the inalienable rights in the Declaration of Independence for all, we should see the 14th Amendment as advancing but not as completing that project. We should therefore accept that it is appropriate to pursue further reforms aimed at egalitarian civic inclusion prudently, patiently, but persistently, as more moderate proponents of progressive constitutionalism urge. My second response suggests that Congress, not unelected judges or executive officials acting unilaterally, bear primary responsibility for crafting and enforcing policies to achieve broader, more egalitarian, and more effective inclusiveness in the American project of securing basic rights of citizenship and personhood. This view of Congress's role is both consistent with traditionalist constitutional conceptions of the separation of powers and with the progressive constitutionalist emphasis on winning reforms chiefly through democratic processes. It may seem wildly unrealistic today to urge reliance on Congress, the branch of the federal government most paralyzed by polarization. But there's also a growing consensus among both conservatives and liberals that it's now vital to reinvigorate Congress. One way to strengthen it is to insist on its special constitutional powers and responsibilities to advance the goals of the 14th Amendment as well as the other post-war amendments. But for Congress to do so, it is necessary for all of us as citizens to seek to build democratic majorities that reach sufficiently broad agreement on policies to win their enactment. Those policies must inevitably involve compromises, hybrids of different political views and interests, even different constitutional visions. Many fear today that our divisions are so deep that we can no longer achieve sufficiently broad agreements to meet the challenges we face. Yet, because of their own principles, both constitutional conservative proponents of popular self-governance, exercised through institutions of representative democracy and the rule of law, and progressive proponents of broadly inclusive and egalitarian democratic reforms should see the quest to achieve democratic agreements on measures to advance our shared political enterprise as the very heart of American citizenship. We should also see that in our body politic, the constitutional location of that heart is the 14th Amendment. Grasping this truth might just help many more Americans to feel that this great heart, with both its right and its left sides, is one they share at the center of their competing yet intertwined conceptions of the American Constitution.
Hello, I'm very pleased to be here. I apologize, I have a bit of a cold, so I might need to drink some water to keep myself from coughing at you. Thank you so much for inviting me. I'm really pleased to be here with you and on such a tremendous panel and with the capacity to be in conversation with so many of you here and the other panelists today. Since the founding era, there have been many different visions of what this republic should look like, who is recognized as an American citizen, what rights citizenship should entail, as well as what type of civic and political leadership is needed. These visions have been often tied to debates over the meaning of constitutional principles in relation to slavery, freedom, and the wide realm of subjection and inequality between them. And it's the intensive civic debates over these issues that have been a crucial part of what's helped define American membership and nationhood as they have unfolded together. So today I want to invite us to consider American citizenship and the Constitution from the perspective of some of the civic actors and groups who've struggled for different visions of the political community and its fundamental law. In particular, I want to consider how some civic interpreters of the Constitution, particularly free African Americans before and after the Civil War, sought to create and then redeem what became the 14th Amendment's promises of birthright citizenship, rights, and equal protection of law is an antidote to conditions of slavery, but also conditions of subjection and discrimination. By contrast, I also want to think about some of the groups that had a backlash to this vision, particularly the Klan and other related white supremacist groups, who attempted to restrict the boundaries of citizenship and equality and the promises of the 14th Amendment, partly by calling for a return to their ideas of what an original Constitution had been. My hope is that this will inform our understanding of some of these divergent constitutional ideas and the social forces that have shaped the path of citizenship, and that this will enable us to grapple with the mixed legacies we've inherited from these groups, which include egalitarian and inclusive views of the American political community, but also include very exclusionary, very racist, and very nativist views. So to begin, Act 1, the Constitution and Citizenship before the 14th Amendment. So the United States and its Constitution were formed with a central contradiction between slavery and freedom. And confronting this contradiction has played an ongoing role in our capacity to define citizenship. While the Declaration of Independence proclaimed that all men were created equal, and the constitutional preamble speaks inclusively in the name of we the people, the 1787 Constitution and the 1789 Constitution, so before and after the passage of the Bill of Rights, did not provide any clear answers to the question of who can claim equal membership in this people. The bare text of the initial Constitution included just 11 references to citizens, but it also made references to Indians and to other persons who were not then considered citizens. It did not include any explicit definition of national citizenship nor any specific list of rights entailed in this. When we read the notes of the debates from the 55 men sitting at the Philadelphia Convention, and there are more than 700 pages of them, we find discussions of many important issues, including the heinous compromises to constitutionally protect slavery without speaking its name, the 3/5 Clause, the Fugitive Slave Clause, and the Slave Trade Clauses. However, we don't find explicit or sustained debates over who should be recognized as a U.S. citizen. There were no lengthy discussions over whether to grant or deny citizenship to the poor or the propertyless, to Native peoples, to free African Americans or other non-whites, to non-Christians, or to women. At the time, none of these groups were widely viewed as capable or worthy of full citizenship, and none were there to stake their own claim. So although the initial Constitution did not list any set of citizenship restrictions, and thus it can be seen as holding radical democratic potential, although I'm going to change that word to possibility after Michael suggested the different meanings, radical democratic possibility, this possibility long remained latent. It was stunted by those slave clauses, and it was still further subsumed by a network of state and federal laws, as well as court rulings, that effectively limited full citizenship and rights to propertied white men. And so as the American nation emerged, only somewhere between 6 and 15% of our population enjoyed full, free, and equal citizenship with suffrage rights. And at the time, this was actually a radically democratic body of citizens. However, around 20% of the population was enslaved. The remaining 60 to 70% of the population, including women, non-whites, free blacks, indentured servants, and poor white men, existed between the worlds of slavery and freedom, in a legal, political, social limbo of subjection and subjecthood. The story of American citizenship is partly a story of how these and other disinherited groups have struggled to claim their equal freedom and membership. So here are some of the significant ways that the boundaries of national citizenship were not constructed by the Constitution itself, but by the interstices between its openings or its silences. Each of these erected steep barricades. First, there were Congress's Naturalization Acts of 1790, 1795, 1798, 1802, which provided that only free white persons were eligible to become naturalized U.S. citizens. Then, between 1777 and 1807, all U.S. states enacted laws preventing women's suffrage and generally continued traditional common law restrictions on women's rights. The Supreme Court's decision in Cherokee Nations versus Georgia in 1831 ruled that Native peoples were not citizens, but members of domestic dependent nations, as Rogers has also pointed out. During the 1800s, a number of northern states also began explicitly restricting the rights of free blacks, sometimes from settlement, sometimes from vocation, often from voting, through what were sometimes called black laws at the time. And then in 1857, the Supreme Court issued its infamous Dred Scott decision, which used the case of a black man claiming freedom to take up the looming question of how to understand the US Constitution in relation to citizenship and rights. That decision said, the question is simply this: can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all the rights and privileges and immunities guaranteed by that instrument to the citizen? Chief Justice Taney answered this with a lengthy interpretation of American history and law. His view was that the Constitution had drawn an impermeable boundary, a line of division between the citizen race, who formed and held the government, and the African race, which they held in subjection and slavery and governed at their own pleasure. Furthermore, Taney insisted that the Declaration of Independence did not mean what it seemed to say. And he included the text in his decision. We hold these truths to be self-evident, that all men are created equal, that they are endowed by the Creator with certain unalienable rights, that among them is life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted, deriving their just powers from the consent of the governed. Maybe consent and dissent. Taney wrote, "The general words above quoted would seem to embrace the whole human family, but it is too clear for dispute that the enslaved African race were not intended to be included and formed no part of the people who framed and adopted this declaration. For if the language, if understood in that day, would embrace them, the conduct of the distinguished men who framed the Declaration of Independence would have been utterly and flagrantly inconsistent with the principles they asserted. And instead of the sympathy of mankind to which they so confidently appealed, they would have deserved and received universal rebuke and reprobation." Thus, he declared under the U.S. Constitution, no person of African descent, whether slave or free, could ever become a U.S. citizen. The Constitution did not recognize Dred Scott as holding any constitutional rights that any state or any white man was bound to respect. He declared it the original intention of the Constitution's framers to permanently exclude African Americans from citizenship as an inferior race. It would take a civil war, the passage of a constitutional amendment, but also so much more to overthrow this restrictive and race-based interpretation of American citizenship. Act 2. The 14th Amendment is a reconstruction of citizenship and nation catalyzed by decades of African American activism. So we know that the 14th Amendment is referred to as a Reconstruction Amendment. When it was ratified over 150 years ago, it forged a new birth of freedom. Its passage represented a crucial legal victory, as we've already heard, that overturned this view of citizenship announced by Taney, a view that, at least among the radical wings of the Republican Party, had fallen into disfavor already. But since even before its inception, the 14th Amendment's public promises of birthright national citizenship, of the privileges and immunities of citizenship, equal protection of the laws, due process of law, and of government enforcement of these guarantees have been a continued source of contestation and aspiration inside and outside the Supreme Court. One crucial part of our understanding of American citizenship in relation to the Constitution involves the history of how leading congressmen, such as Bingham and other radical Republicans, debated and negotiated and strategized the adoption of this amendment. And Lash has spoken of that very eloquently. Another crucial part is how federal courts and judges have interpreted the 14th Amendment. As students in constitutional law and civil liberties courses learn, much of the development of modern American rights and governance pivots or hinges on the judicial interpretation of the 14th Amendment and its guarantees. Equally crucial, though, is this third overlapping strand of constitutional development I now want to turn to. What U.S. citizenship has meant to those who have struggled to claim citizenship and rights for themselves, as well as the history of those who fought against expansions of citizenship. As I discuss in my book, The Civic Constitution, and many other scholars also show, our troubled history of legally restricted citizenship is entwined with another important history of civic vision and struggle among the groups who sought to claim citizenship and rights for themselves. Among the most important but least known and credited and recognized groups that developed and struggled for the ideals now reflected in the 14th Amendment were the free African American men and women who developed and participated in the so-called colored conventions, the improvement societies, the anti-slavery leagues, and the equal rights leagues of the 19th century. And Sue earlier spoke of how ennobling and powerful civic action is. And when we go back and read the debates and the writing and the activities of these groups, we really feel that power of civic action at work. These groups of free and fugitive blacks began emerging and spreading across the North in 1830. They were in New York, Ohio, Michigan, Massachusetts, Maine, New Hampshire, Kentucky, and beyond. After the Civil War, they quickly spread to the South. The delegates to these meetings included writers, many ministers, newspaper editors, entrepreneurs, tradesmen, many of the most prominent voices of early African American leadership, such as Frederick Douglass, but also many unknown members. For decades before the 14th Amendment, those who participated in these groups and meetings and activities were asserting and circulating the view that African Americans were already birthright citizens, deserving equal rights and privileges under the Constitution. They were the architects of these ideas. Before the war, they strategized about how to achieve educational, labor, and legal justice at a time when the rights of free blacks were also limited and increasingly threatened within states and nationally. They were the architects of the first ideas of civil rights laws. After the war, they continued convening and pushed forward the ideas of the 14th and 15th Amendments, as well as other political goals, where they were taken up by Republican congressmen. From their first published meeting of a colored convention in 1831, these African Americans made their constitutional views, their vision of citizenship, very clear. They called for both the Declaration and the U.S. Constitution to be read in their conventions. This is because they believed that the truths contained in the former, the Declaration, are incontrovertible, and that the latter guarantees in letter and spirit to every free man born in this country all the rights and immunities of citizenship. This was in 1831, before there was a Republican Party, before there were any political leaders who considered these credible ideas, and they were creating them from their own readings of legal treatises, from their readings and interpretation of the Declaration of Independence, and their readings of the Constitution. They condemned what they considered, quote, the many oppressive, unjust, and unconstitutional laws which have been enacted in different parts of the Union against the free people of color. Foremost among their many discussions of political and social issues of the day were their condemnations of slavery, but also calls for recognition of citizenship and equal rights. Oh my goodness, I'm really going to run out of time. Let me strategize how to cut this short. I'll give one example. In this and other conventions, they repeatedly referred to themselves and each other as citizens, fellow citizens. They described the political plight they faced as the phenomena of an oppressed people deprived of the rights of citizenship in the midst of an enlightened nation. They lacked political representation and thus could only hope to sway white citizens through their moral suasion. In the years before the Dred Scott case, they were asserting an alternative vision of their status and an alternative vision of citizenship and ennobling it. And I think I have more to say about that, but just as a contrast, I'll just give you a little of the sense of Act 3, which is the backlash. So after the passage, the adoption of the 14th Amendment and the other Reconstruction amendments, there was what Michael Klarman and other constitutional scholars who study change and development in the Constitution suggest as backlash effects and counter movements. The most influential of this movement was the KKK and Klan-related groups that sprang up after the Civil War had ended. While we think we know the KKK, and we know a fair amount about the violence that they've engaged in, we know much less about the fact that they were actually very devoted in their own minds to the Constitution, a Constitution as they understood it. Their tenets for this constitutional vision or their constitutional views can be seen from their earliest organization. They described themselves as having a purpose of, quote, to protect and defend the Constitution of the United States and all laws passed in conformity thereto, and to protect the states and the people thereof from all invasion from any source whatsoever. They proclaimed themselves the defender of law and the Constitution against, quote, the lawless, violent, and brutal, with no hint of irony. Their white supremacist understanding of the Constitution was indicated by the questions they gave to potential members, such as the following. Are you opposed to Negro equality, both social and political? Are you in favor of a white man's government in this country? Are you in favor of constitutional liberty and a government of equitable laws instead of a government of violence and oppression, which is how they interpreted the Reconstruction government? Are you in favor of maintaining the constitutional rights of the South, which they believe had been deprived by both the Reconstruction amendments and the terms of Reconstruction? Are you in favor of the reenfranchisement and emancipation of the white men of the South and the restitution of the Southern people to all their rights, alike proprietary, civil, and political? As the Klan shifted its approaches and its views over time and resurged in the 1920s, it took on different views, but the core of white nationalism remained the same. They continued to refer to themselves as dedicated to an original version of the Constitution as they understood it, which was a social contract for whites. They penned elaborate rereadings of American history that included sharp condemnations of Lincoln and the Republican Party for their failure to, quote, be true to the Constitution and the spirit of '76. In the eyes of the Klan, they were the ones who were faithful to the true Constitution, which had established white rule. So in conclusion, skipping a lot of material I would like to share but cannot, I'll just say a bit about these two legacies. So these historical dynamics of struggle and aspiration and backlash in which different groups of Americans have engaged are offering, I think, several challenges to the ways that we usually approach American constitutional development. Our discussions and our teaching of nationhood and citizenship and the Constitution tend to place great emphasis on ideals and goals harking back to the revolutionary and founding decades of the 18th century. The ways that different groups have interpreted the ideals of the Declaration and Constitution have sometimes limited their promises to the racial errors of 1776, treating these as frameworks for racism and xenophobia. Others, however, such as the free African Americans participating in the colored conventions, the free societies, the benevolent societies, have been those who not only envisioned their own citizenship, but shared a future ideal of a more racially egalitarian and inclusive community. They did not achieve all of their transformative goals, but they created a potent constitutional vision that was marked by the 14th Amendment and other Reconstruction amendments, and they left this legacy, this gift, to us. Recovering some of their constitutional views, as well as the views of other groups that have tried to shape legal conditions and political status, shows us how some sought to migrate from a world of subjection and slavery to a world of freedom and equality. And it provides a sense of the historic struggles over citizenship that have come before us. It can also afford us a deeper way of thinking about the ongoing struggles we see today. Thank you.
Thank you so much to our panelists for those incredibly eloquent and informative presentations. We have a microphone here for questions, but I thought I would kick off with a question to the panelists. And I want to just first begin by saying that whenever I teach Reconstruction in my con law classes, I'm always impressed when I go back and read the debates in Congress over the passage and enactment of these amendments, as well as the enabling laws. I'm always shocked, frankly, at the level of sophistication, constitutional law that is seen in these debates. And I see that Kurt is shaking his head in agreement because it is truly inspiring to read the words of John Bingham and others in these debates. And it really is helpful, I think. I tell my students, go back and read these debates because it really will help you understand the Constitution, perhaps better than I can teach it to you. So it's extraordinary. And I want to commend Professor Lash for, as I understand it, putting together an encyclopedic set of books on the Reconstruction amendments and documents associated with that. And I think that's a really great exercise, and I'm grateful to him for that. I wanted to ask a question about the legal meaning of citizenship under the 14th Amendment. Professor Smith noted that the 14th Amendment talks about birthright citizen, all persons who are born, I don't have the language in front of me, but born in the United States are citizens if they're subject to the jurisdiction thereof, and then noting that there are a number of exceptions in Section 2 that sort of draw away from that, what seems to be a very comprehensive statement in relation to Indian tribes and women, et cetera. And I'm just interested in the current debates over, and he mentioned in his comments about whether or not, or that the fact that the court had not yet addressed the question whether someone born to someone who's in the United States illegally, whether there is birthright citizenship there. And I'd be curious as to what are the contours of the legal arguments associated with denying birthright citizenship to children of illegal aliens or individuals here in the country illegally, and then what is the counter arguments to that? To that argument that's made by some, I think, in politics today. I'm just interested to hear what you have to say, and I'm sure all three members of the panel are interested in that topic too. So.
Sure.
Well, I'll start since I've written some controversial things on this topic. I've always favored birthright citizenship for all as a policy, but we do wrestle with the fact that right in Section 1, there is a qualifying clause and subject to the jurisdiction thereof, and we wrestle with subsequent Supreme Court decisions that have interpreted that clause in ways that have denied birthright citizenship to several classes of persons. I don't agree with all those decisions, but they are part of constitutional law, and there is a great deal of debate over what that phrase means. It clearly meant to exclude Indians not taxed, or came to be understood as Indians born into tribes. There are lots of different accounts of why they didn't include them. Some say it's because they were sufficiently independent that the federal courts didn't regularly rule on issues involving them, but the federal courts did rule on issues on appeal from them. Peter Schuck and I argued that the clause might be read as indicating that citizenship in a constitutional democracy should be a matter of mutual agreement between the existing citizens and the potential citizens, and that agreement was lacking with the tribes. That's often countered by the quotations that Kurt rightly referred to, saying that, well, Chinese immigrants will be included, gypsies will be included, and the Supreme Court did ultimately extend birthright citizenship to Chinese immigrants, but those were the ones who were authorized immigrants, legally accepted. I've taken the view that because I believe in a constitutional democracy, we should rely fundamentally on democratic processes, that since there is no explicit discussion of the children of unauthorized aliens. At that time, there weren't national restrictions on immigration except for a ban on the slave trade, and there was no discussion about the status of children of former slaves in when it was illegal to have the international slave trade. There's simply no discussion of the status of children with unauthorized aliens, and I think under our system, if there's no express constitutional intent, the default is that Congress gets to decide, although I would like Congress to decide generously. But there are many others who insist that, look, the basic message of the 14th Amendment was inclusion, and if this group is not explicitly accepted, it should be counted as included amongst birthright citizens, and that has been our practice. In this case, you can appeal to this longstanding practice and say, that's the best interpretation of the 14th Amendment.
Yeah, that has become a constitutional norm.
Yeah.
Any other panelists? Question? Go ahead, Kurt.
Oh, and just briefly, you know, thinking about the conversations that they had at the time over subject to the jurisdiction thereof, who would it include? Well, it would include Indians not taxed. That's an unusual phrase, right? We don't think in those terms today. But once again, if you consult the original documents and the original speeches, they go into some detail as to what that term means, why it's important, why you would distinguish between those Native American tribes with residents in those tribes who remain under the sovereign authority of those tribes, as opposed to those who were being integrated into American society, and therefore were subject to taxation, and now had all the duties and responsibilities of citizenship. And so, they're very sophisticated arguments, and I do very much encourage those of you interested in it to consult them. You'll learn a great deal about sophisticated legal arguments on the parts of all the people who were engaged in crafting the amendment. I also agreed with Rogers that the particular issue of the children of people who were illegally in the United States simply wasn't on the table at the time. It's a modern issue, and in trying to get clear answers out of this set of historical materials is just going to be difficult because it wasn't on the plate. I will say this just briefly, though. The idea of children of groups that were not particularly well received was on the table at the time. Chinese immigration in the West was becoming an increasing issue in public debate. It wasn't on the table at this particular moment beyond those representatives from California who liked to talk about it. They were beginning to tax Chinese labor in an effort to decrease it, but we didn't have exclusionary rules at that point. And that's why when Howard proposed his citizenship clause, he was immediately challenged as saying, well, you seem to have a very narrow category of people being excluded. Are you actually suggesting that the children of gypsies and Chinese immigrants are going to be allowed to be citizens of the United States? And Jacob Howard's answer was, I thought, quite lovely. Absolutely. And that was all he said.
Thank you so much. By all means, audience members, come up. I certainly have more questions, but
I had a question mainly for Professor Lash here. And from something you said, if the Privileges and Immunities Clause only secures the rights of citizens and the Due Process Clause is relative to a different category, persons more broadly, does that make the Supreme Court's doctrine of substantive due process a complete constitutional aberration?
Oh, there are so many things that make it a complete constitutional aberration.
Well,
I just do not have time right now to go into detail. Yes, and your question's quite right, and it raises a difficulty. The court, for a variety of historical reasons and a variety of historical precedents, did not develop two distinct areas of jurisprudence for citizens in the United States versus the rights of all persons. As you move into the 20th century, all the attention of rights, whether you were a citizen or not, all became stuffed into the Due Process Clause. And the court has struggled with its interpretation of that clause because it does make distinctions under that single clause in terms of whether or not do people who are not citizens have right to bear arms or can engage in certain associations or things along those lines, things that citizens would clearly have rights. So it is struggling under its jurisprudence of substantive due process. And the reason why it's struggling is that it has no textual or historical guide trying to get all of it out of due process. So I think that's a problem, and I am one that me, along with many other legal historians, hope that the court will eventually remedy. So good question. Thank you.
can I ask a follow-up question to that? While others come to the microphone, I was struck by how clear it was that you noted John Bingham he was very clear in his statement that the Privileges and Immunities Clause was intended to incorporate the first 8, at least, amendments
Yes.
as against the states. Yet that language of his apparently had no impact on the Supreme Court for quite some time. Why?
Yes. Well, again, something that scholars have struggled with. You get 2 early decisions from the Supreme Court that seem to reduce the Privileges or Immunities Clause to almost nothing. The first case, the slaughterhouse cases, I think 1872, 1873, we're now about 7 years out from the drafting, right? And the original national conversation, which is really around 1866, 1867. And the slaughterhouse cases do not deny that the privileges or immunities of American citizens includes the Bill of Rights. The slaughterhouse cases is a very narrow decision that says that privileges or immunities do not include unenumerated economic rights to engage in a trade. That's all the slaughterhouse cases decided. Then about 5 years after that, you get Cruikshank. And Cruikshank, we're now, over a decade beyond when the amendment was debated. John Bingham is now in Japan And most of the people who are involved in it have moved on or are no longer in Congress, not all of them. But Crookshank, in just a terrible situation involving the Colfax massacre, denies that blacks have rights that need to be protected against state action out of the Bill of Rights, because everyone knows the Bill of Rights doesn't bind the states. So it's really Crookshank that brings it to a close. And of course, it represents a period where the efforts to secure equality for blacks in the South was also coming to an end. We're right at the end of Reconstruction. And so I suppose I'd put myself in the camp of political weariness, that the people of the country for a time can focus on the broader issues of the public good, but it only lasts for a certain amount of time, and then we go back to just being private-driven people again.
You know, Crookshank, one of the most impactful Supreme Court decisions that no one's ever heard of. So.
Yes, yes.
Hi, thank you. So back in September, I'm very short, so there we go. Back in September, I was on a work trip in Israel and the West Bank, and we were meeting with some Christians in the Middle East and regarding their situation. So in a village in the West Bank, I was talking with this man, and he told me that he had saved up some money, and he is sending his pregnant wife to Michigan so she can have the baby, and that was going to be his ticket out. And I've kept that to myself, and because he told this to me in confidence, because I'm Iraqi. You know, I wasn't just an American to him. I was a Middle Easterner to him. So I have my own ideas on how to relieve those kinds of situations, but I wanted to just put that before you, and maybe you can say some ideas, or if you've thought about it, or what sort of solutions you think are a possibility for this kind of situation. And he's not the only one.
So is the question what, in terms of our approach to constitutional interpretation, could be done? Maybe just a little clarification on what you're, would this fall into the category of not recognizing this as
Well,
a
it's
birthright
both and.
citizen?
I mean, you can certainly discuss what can legally be done, or if anything should be done. Maybe we should just allow this, and this is the only form, by sort of turning a blind eye to it, we can provide the relief and just hope that someday things will be okay. That could be an answer, certainly, unless you have another idea, or if you've thought through it, or if you think, no, we need to shut it down completely. And so, yes, both and.
Well, I'll just say that there is a real phenomenon. There are services, especially serving crazy rich Asians, that allow people to come to this country and give birth in order to establish citizenship, with the notion that that might be useful to the family later on. And these practices are one of the sources of opposition to birthright citizenship. I don't think that they represent a major public policy problem personally, because they are limited. It's also true that until the child becomes an adult, their capacities to bring family members in under American, as relatives of a U.S. citizen, is very limited. We have more problems with our policies separating families than uniting them on our soil in ways that we don't want. And sometimes the policy does serve humanitarian purposes, as your example suggests. So I don't see a strong reason for change, but in an ideal world, we would make decisions on humanitarian assistance and inclusion through mechanisms that are more direct than this birthright citizenship stuff.
And if I could just very, very briefly, because again, we know there's a national conversation, there's a big political divide in terms of what to do about immigration, concerns about securing borders, concern about how people are using current immigration laws. This is one of the reasons why I'm not a living constitutionalist, okay? Because, you know, here's one way to approach the question. They didn't anticipate what might happen to immigration policy over time as transportation increased and as the benefits of coming to the United States increased and as concerns about national security, whatever it's going to be, increased. And so whatever was the original understanding of the 14th Amendment, maybe it was open to everyone, even those the children of those here illegally. Over time, we should interpret those words to allow the government to take control of what is a new problem, right? I don't take that approach. I think that leads to the internment of Japanese Americans. I don't think that that's the way to go about engaging the Constitution. If we have current problems with immigration, it may be either that it can be taken care of through legislation and national conversation, or we might be looking at a constitutional problem. Maybe we should take another look at the 14th Amendment in terms of how it affects immigration. But the way that I wouldn't look at the problem would be, gosh, whatever they thought back in 1868, look at the problems that have developed this generation. We should interpret the Constitution to be more flexible and allow the treatment of this population in a way that wasn't anticipated in 1868. That, again, I think that's a problematic way to go about looking at the 14th Amendment.
Thank you. Thank you.
Hi, everyone. Thank you for coming today. Although I'd love to hear your opinion, Dr. Smith and Dr. Lash, my question is specifically for Dr. Beaumont and the backlash that happened towards Reconstruction. My question is, why did the federal government take its foot off the gas pedal? You referenced specifically how white Southerners who renounced their rights to U.S. citizenship, that were in active rebellion against the United States government, had the audacity to later say that they had been disenfranchised by a government they rebelled against. So I guess in short, my real question is, why did the federal government cede power to the states that had been in active rebellion against them just 10 years ago? States that we knew weren't going to enforce the Reconstruction Amendments and were not going to do their job as state governments.
Well, earlier Kurt used the term political exhaustion, and I think a combination of the political exhaustion of maintaining a military presence and military rule, and the sense of how illegitimate it was perceived by those who were there, became politically unsustainable, financially unsustainable, militarily unsustainable. And I think there was a sense of the need to move on, and the collateral damage of the need to move on was the loss of a brief period of real promise during Reconstruction, when blacks were voting, when they were holding office, when there was a real period where the promise of those Reconstruction amendments was being borne out. There were black schools being established, and so you could kind of see that window of possibility or potential opened, and then when military Reconstruction ends, and then when we have the compromise that leads to the shift in political power, completely closes. But it is, I think, one of the most frustrating parts of the history of Reconstruction, that it seemed that there was real possibility there. And as W.E.B. Du Bois had argued, Black Reconstruction had there were some real gains being made, and then it all almost became for naught, in the sense of that there was such a complete clamp down on any gain that had been made, that it was almost that it had barely existed at all.
Cool, thank you.
Hi, my question is also for Professor Beaumont. So I found this idea really interesting, kind of looking at, whereas maybe Dr. Lash and Dr. Smith had taken more of a legislative approach to the amendment and to the interpretation of the amendment, how the ideas of people really influence this, how they influenced this idea of citizenship leading up to the passage of the 14th Amendment, and then how the ideas of the people responded to the passage of the 14th Amendment. And so my question would be for this going on, I mean, obviously the question of citizenship is not a settled question. It's something that is always likely going to be a point of debate, and especially today in terms of illegal immigration. And so my question would be, do you believe ultimately that the ideas of the people, which obviously will fuel legislative amendments, or the legislative amendments themselves win out in this idea of citizenship? So if people disagree with a legislative amendment that's been passed, will their ideas of citizenship and what they believe citizens are win out, or does the idea of citizenship as an institutional virtue determined by the institution itself?
So, as you said, there are very few, even things that can seem very settled. For a long time, birthright citizenship seemed very settled. It now seems unsettled. So even things that can seem very settled can become unsettled, and it's often through kind of new events, new challenges, new crises that create a lot of foment and division and debate in a population, and competing sides and competing positions that then influence what happens in the political sphere as well as what happens judicially and with court interpretations. And I guess one of the features of the U.S. Constitution is that there are multiple arenas for contestation and dispute. And when there is a group that disagrees with what one branch or level of government has done on any particular question, they often go forum shopping or arena shopping for a more friendly, more open voice. It's generally the case that a movement or a group on its own, without political allies, without a party to take up its views, without political leaders who adopt a particular agenda or perspective, are very likely to be able to make any real gains, right? That's and so you kind of need to have these partnerships and alliances, but even there's always potential either for, well, there can be backlash to the backlash, competing institutions who, when the institutions may not be aligned, one institution may be doing one thing with the right hand when another institution wants to do something with the left. And we, sometimes even see that in this current moment where, an executive branch can have one perspective, a judicial branch can have another. And so I feel that it's very much part of the constitutional system to have ongoing debate and contestation around all of our most heated issues with no maybe periods where there's greater settlement, but no final settlement, which can be a good thing and a bad thing, depending on the issue or sort of how you feel about where the current moment of settlement is or is not. You may find it very frustrating that something that you feel very strongly should be the case becomes unsettled, or you may be very happy that even things that you dislike or you feel are very unjust at some point have an opportunity to be reopened and brought into civic debate as well as kind of institutional debate.
Thank you so much.
We have 1 minute left, but I think we can squeeze in one last question, so thank you so much.
Thank you. I've heard the argument that the notion of voter suppression is total BS, while others say that it's very real and it's a dirty political trick by the Republican Party to maintain their power, whatever power they have, as long as possible. Could you guys comment on that, please?
On the issue of vote suppression, and is it a reality? Yeah.
Well, some people have argued it's not real, it's not an issue. Well, no, they say it's, no. I've heard the argument that if you can't quantify it, that it doesn't exist.
Well, this is something I have researched and written on, and it is historical fact that the claims of fraudulent voting that have given rise to a variety of new voter registration requirements, including ID cards and other provisions that are called vote suppression because they do reduce voting participation. These measures trace in the modern era to the passage of the Motor Voter Act under Clinton, which led almost immediately, because it expanded the franchise, or more people got registered, more people were voting. They were disproportionately people of color, and it is true that Republicans at the state and national level then began introducing bills that were said to be aimed at preventing vote fraud. And it is also true that scholars and governmental commissions, including the commission appointed by President Trump, have looked again and again for evidence of in-person vote fraud. And no one has ever found substantial vote fraud. So it is clear that these laws have partisan consequences. It's clear to me that they're not based on the discovery of any real problem of vote fraud that needs to be addressed. So do they constitute improper modes of vote suppression? Citizens can make their own judgments.
Thank you so much, Rogers, from a political scientist. We appreciate that perspective, and thank you to our panelists for really, truly an edifying discussion and presentations. Thank you so much.